Good, we're live. Hi everyone on this somewhat sunny Tuesday afternoon. It's lovely to be here for MyHR's Facebook Live 12. Jason, our glorious leader and CEO, is off travelling, so I'm taking this one on his behalf. And we'll be talking about wage deductions today, which can be quite a contentious issue. So we wanted to go through what you can and can't do, what the law allows you to do, and talk about some of your options if you are looking to make wage deductions. So you're fully prepared and know what you might come up against when you're looking to take money back off your employees, essentially. So, a bit of housekeeping before we start. As always, ask questions as we go through. At the end, we'll collate the questions and then I will answer them for you. So we'll do that at the end of the talk. This is being recorded, of course. So if you have a sensitive question or if you want to ask a question anonymously, please do so. If it's quite sensitive, maybe ask it offline or get in touch with us later. So this will be recorded. It will go up on LinkedIn, on Facebook, and on our YouTube channel as well. So if you don't get to watch all of it, or if you're having technical difficulties, you can always watch it later. So that's good to know. And if you do have any questions at the end of the recording or at the end of the Facebook Live, let us know through any of those channels, LinkedIn, Facebook, YouTube, and we'll make sure we come back to you with an answer. So wage deductions, it's a contentious topic. Anything to do with money will often get tempers quite hot, especially when money is a proxy for doing the right thing by your employee or your employer. So an overview of what we'll talk about today, we'll talk about the different types of wage deductions, because some of them of course are different to others. We'll talk about the Wages Protection Act and what rights it gives employees. We'll talk about actually making deductions. I'll run through some typical scenarios that we get asked about on a daily basis here at MyHR, and then we'll do a wrap up just to summarize some of the points from our discussion today. So to kick off then, there are three types of wage deductions. The first are the ones required by law, so ACC, PAYE, child support, all those kinds of deductions. This talk and the Wage Protection Act doesn't apply to those types of deductions. There are other statutes and other laws that govern your obligations to make those deductions and send the money where it needs to go. So PAYE, ACC, child support, all that kind of stuff we won't be talking about today because they're not deductions that an employee can say no to. So the other two categories then are miscellaneous kind of regular deductions, which might include KiwiSaver, which employees can opt into. It would include things like unions and social clubs, again, where employees are opting into those payments. And they're regular payments because you are regularly making a deduction for union fees or for social club fees or what have you. Irregular deductions, which are the third type of deductions you can make, are things like repayments for lost or damaged property, deductions for bonding costs, if they haven't returned a uniform or other company property, those are more irregular deductions. So we talk about them as being regular and irregular just to kind of make a difference between scheduled deductions and then things that might happen as a one-off, but materially both are subject to what we'll talk about today in terms of what you can and what you can't do with your employees. So this brings us to the Wage Protection Act. So the Wages Protection Act was a 1983 piece of law, so it's been around a long time. And the main point to be aware of for our discussion today is that it gives employees the ultimate authority to decline for any deductions to be made from their pay. Okay, so it's section 5 or 6, I think, where employees can say, I don't want any further deductions to be made from my pay. They have to tell you in writing, and within 2 weeks, or as soon as is practicable, you have to stop making those deductions. So like I flagged earlier, this doesn't apply to compulsory deductions. So ACC, PAYE, it would be a bit of a disaster if employees could say, I don't want to pay any more tax, and you had to go along with that, so they can't do that. But other deductions, we're only talking about type 2 and 3 deductions, so those regular and irregular deductions that you're making from your employee's pay. So this has been the law since 1983, it's not a new law, and where this gets contentious, of course, is if they're saying to you, I don't want to be part of the social club anymore, and they're saying they want those deductions to stop. That's pretty reasonable. Most people wouldn't have a problem with that. But where it's something like they've agreed to repay agreed to repay money, you've lent them to buy some tools, you're going to feel pretty aggrieved as an employer because you've given them $850 to buy some kit or some equipment, and they've agreed to pay you back at $50 a week, let's say, and you're now saying, the employee is now saying, I don't want you to make those deductions anymore. So it can be quite a fraught area. We often get feedback, or we often have clients say to us that the law is always in the employee's favour. This is one area where it definitely is. It's called the Wages Protection Act, not the make sure everyone is treated fairly act. So it's very clearly giving employees a lot of authority and a lot of, decision making and prerogative around how their money is spent. So moving on to the next topic, and this is where you are making deductions or wanting to make deductions. So this is often triggered when an employee has resigned or is leaving your employment, and you've done your accounts, you're looking at what you've got to wrap up before you go, and you realize that they've owed you some money. So this is when this kind of comes into play. The next point to make is if in the employee's employment agreement you have a general clause saying something to the effect of we as your employer can make deductions as required for things like overpayment of wages or damage or what have you. If it's a general clause and doesn't give specific criteria under which you can make those deductions, you must propose the deduction to the employee before making it. Okay, so if you have a general deductions clause and you're wanting to make a deduction under that clause, you must propose it to the employee and get their sign off. You can't just say, hey Steve, I've overpaid you $1,000 and so I'm going to be making deductions of $100 a week for the next 10 weeks. You have to get the employee's agreement to that. If you have, on the other hand, a specific deductions clause, something that might say, and one that's quite common, is any training will be repaid by the employee if they resign or leave employment within 6 months of completing the training. That would be a specific deductions clause because it gives you specifics and the conditions under which you'll make the deduction. We would still advise proposing this to the employee for a couple of reasons. So the first reason is that the law says you can't make unreasonable deductions. There is a very clear clause in the Wages Protection Act which says unreasonable deductions can't be made. So defining what's reasonable and what's unreasonable is a whole other conversation, but getting the employee's agreement to that deduction being made goes a long way towards showing that you are making a reasonable deduction because you've consulted with the employee and the employee's agreed to it. The other reason we say that you should consult when making a specific deduction is it's good faith to do so. I mean, if the only grounds on which you're making this deduction is a clause in someone's employment agreement, they might not have looked at that agreement for a couple of years or 5 years or 10. So expecting them to remember and to reasonably expect a deduction to be made if they haven't seen their agreement for a few years would be unreasonable. So that's why we suggest or advise consulting with an employee even when it's a specific deduction, and it's also why me and the team will advise getting bonding agreements where possible. So if you're lending someone $1,000 to buy a car because their car broke down, if you're paying for them to attend a $10,000 training course and you want to be able to claim that money back, having a bonding agreement in place shows that you consulted with the employee, you got their agreement, you reminded them that you can make this deduction, and you're complying with your good faith obligations, basically. So, where it gets contentious is if an employee says no and doesn't agree to a deduction being made. Whether that's a general deduction, you overpaid them $180 and now you want to claim it back. Whether it's a specific clause and they're refusing to pay back half of their training costs because they're leaving within a certain amount of time. You have two options, basically. You can make the deduction anyway, against what the law requires you to do, and hope a lawyer or an advocate doesn't get involved. Or your second option is to not make the deduction and then pursue them either through the Employment Relations Authority, which is the first decision-making body in the employment law hierarchy, or through the Disputes Tribunal, which used to be known as the Small Claims Court. So those choices again, if your employee says no and doesn't agree to a deduction being made, first option is make the deduction anyway. Second option is to not make the deduction and pursue them through other avenues. Point to note, because we're advising or we're giving you options that are inconsistent with what the law requires. If you do make a deduction after an employee has said no and they get a lawyer or an advocate involved and they're asking for the money to be repaid, at that point the employee does have a grievance against you. So we'd advise fixing the issue by repaying them the money you have deducted, and then seeking other legal advice or giving us a call and we can take it from there. Okay. So running now into our typical scenarios, and this is the last piece before we'll wrap up and answer any questions you have, so we're getting through content quite quickly. Typical examples, and we've pulled these from our experience here, so this is all stuff we get asked quite regularly. I've lent an employee $1,000 and they've been paying me back at $50 a week. Fine. They've left and are refusing to pay me back. What can I do? So the choices again there are, if in their final pay they have enough money to pay you back, you can make the deduction and not ask them and see where the chips fall and see if they come back to you. You can propose taking the money out of their final pay if you think they're a good person and will agree to that, because that's what you've agreed. And if they say no to that, you then can make the deduction anyway, or you can go and pursue them through those other avenues. It also, I cannot iterate or reiterate enough the need to have this kind of stuff in writing, especially when money's involved and employees are trying to take you for a bit of a ride. Having something in writing that said they agreed to these repayments being made for this $1,000 loan goes a long way to showing that you're acting as a reasonable employer. Doesn't always mean you can claim the money back, but it gives you a stronger platform to try and do that from. Another scenario, I have a bonding agreement in place with one employee and she's left after 11 months. So she needs to pay me back 20% of the training costs. So those choices again are the same. Because you've got a bonding agreement in place, if you just wanted to go ahead and make the deduction, you could. However, if when she's resigning, she gives you a letter saying, "Hi Sylvie, I've resigned, I'm leaving, this is my 4 weeks notice. Also, I don't agree for these training cost deductions to be made." She's invoked that authority she has under the Wages Protection Act to not pay that money back. So at that point, your choices are propose the deduction and hope she changes her mind and agrees, make the deduction anyway and see where things fall out, or don't make the deduction and pursue her through the Employment Relations Authority or through the Disputes Tribunal. Next one, and this happened 2 days ago, so it's quite a recent example for us. My employee has resigned but has only given me 2 weeks notice, not 4 weeks notice. Can I deduct the cost of the 2 weeks she didn't work from her final pay? The answer is maybe. So if you, in those 2 weeks, had to hire someone else as a contractor or attempt to do her work, so say you pay this employee $25 an hour, but for the 2 weeks that she now isn't giving you, you then had to engage a contractor at $30 an hour to do the work she otherwise would have done. You can try and claim back the $5 difference between her $25 an hour rate and the $30 an hour rate the contractor charged you. Again, you need to propose the deduction to her. If she agrees, great. If she doesn't agree, make the deduction anyway, see what happens, or don't make the deduction and take it from there. What you can't do is deduct the entire cost of those 2 weeks from her final pay. That's a penalty for leaving or a penalty for not completing her notice period. And the case law is really clear that you cannot make deductions from wages as a penalty or to try and enforce a particular behaviour. So if because she left early you incurred an extra cost, typically the extra rate of a contractor or temp, totally fine, you can try and get that money back. But you can't try and have her work the 2 weeks and then the 2 weeks that she didn't work, deduct that off, because you're effectively penalising her 2 weeks pay for leaving early, which you can't do. Or you can try, but it's unlikely to come off. Next one, my employee had no annual leave left and we agreed for him to take 2 weeks annual leave in advance. He's now resigned and has decided to stay overseas. Can I claim back the 2 weeks paid leave that we agreed to pay him that he wasn't entitled to? Same rules apply. You need to propose the deduction. If he agrees, totally fine. If he doesn't agree, then you can make the deduction anyway or try to claim the cost back the other way. Hopefully you're seeing a pattern here in terms of what you can and can't do. My employee has resigned but hasn't given me the uniform back. This is a common one. Can I deduct costs from their final pay? We typically advise that in the communication to the employee, you say to them something like, you need to return your uniform to you. We are withholding the cost, or we are withholding the value of your uniform from your final pay until we get it back. So we're avoiding using the language of deduction, but you are still keeping that money until they return the uniform to you. This will also depend on whether you had a specific clause in your employment agreement. It always comes back to what's in writing, of course, saying that you could make the deduction if they didn't return the uniform. If it was just a general clause, it will be harder to recover the money. Next one, my employee is not resigning, but they've lost a company phone. Can I recover the cost? Again, it depends on what's in the employment agreement. If they've lost it because they were being negligent, if they were partying at 660 over the weekend, or if they were at Splore and lost the phone, that's very reasonable to try and claim that cost back. But if they had their car or company car broken into and their bag stolen with the phone in it, it would be hard for you to justify claiming that cost back because you would normally claim that on your insurance. So the conditions under which they've lost the phone matter, and the clauses in their employment agreement matter as well to see whether you can try and claim that back. If it's a reasonable deduction, the process would be proposing the deduction again, or proposing a repayment scheme, which might be $50 a week or $100 a month or whatever it is, getting the employee to agree, and then if they don't agree, making deductions anyway or pursuing other avenues. Second to last one, an employee has agreed that I can deduct costs from their final pay for a thing, company phone that they've lost, uniform they haven't returned, but they don't have enough money in their final pay for me to recover the costs. How do I recover what's left over? So they've agreed you can recover the money, but if their final pay was $500 and they owed you $1,000, that's $500 that you're missing. So your options from there are to agree a repayment plan with them outside their employment relationship with you. They don't have a lot of incentive to agree to that, so you're kind of relying on them being a good person, or you can go through the disputes tribunal or the employment relations authority to try and recover what's outstanding. Last one, a money lending agency has come to me, so Harmony or Moolah or any of those agencies, and said that they are owed repayments from my employee and have asked me to make deductions to repay the agency. Can I do this? In this case, you're trying to recover, or you're acting as the go-between to recover money for someone else. So the process is the same. You need to let the employee know that this agency has asked for you to recover costs. If the employee says, yes, that's fine, no problem, that's cool, you can go ahead and set that up with the agency. If your employee says, no, I don't agree for these deductions to be made, you need to go back to the lending agency and say, the employee said no, as their employer, I can't make these deductions for you. The agency then has to go around you using a debt collection agency or similar to try and recover the money. So that's everything in terms of covering off the points for discussion today. In terms of a wrap up then, the main pieces from our side where we try and help clients recover monies from employees. First of 4 tips is get everything in writing so that you stand a better chance of making deductions if you do need to. Second point is that employees have the ultimate right to say no, and this is very clear in the law, to any deductions that aren't required, like ACC or PAYE. If you do want to make deductions, proposing this to the employee is required under a general deductions clause, and we advise it under a specific deductions clause. And finally, if an employee says no, you can always go ahead and make the deduction anyway, but if they challenge you, we would advise backing down, paying the money, and then seeking legal advice from there. So that was a lot of content in 20 minutes. That was everything from my side. Do we have any questions come through? No, I'm getting the shake, so nothing coming through at the moment. Thanks again for watching. It was lovely to talk to you and have a chat over Facebook. If you do have any questions, fire them through on the video. The video will go up on Facebook, on LinkedIn, and on YouTube, and we'll share it around. So if you missed anything or want to recap, it will be available. But thanks again for your time, and looking forward to seeing you again next time.